So a doctor can get into trouble if they don't properly explain that there is a medical assistance in dying option. And so that's where it starts interfering with other people's rights. Well, okay, I don't want to talk about that. I don't want to raise that as a doctor. I'm like, wait a second. Now you're not. This is misconduct. You are not following. You're not providing full spectrum of care to this person.
Hello and welcome to Collapse Life. I'm Zara Sethna. If this is your first time with us, thank you for being here. It's great to see you. Please don't forget to hit the like and subscribe buttons before we get going. Today, we're exploring Canada's creeping authoritarianism, from lockdowns and hiking bans in Nova Scotia to government snitch lines, and now the expansion of medical assistance in dying, better known as MAID. Our guest today is Canadian lawyer and advocate Daniel Freiheit, founder of Lion Law and Lion Advocacy. Daniel's work is rooted in an oath he swore nearly 20 years ago to defend rights, safeguard freedoms, and champion the rule of law, all of which seem a bit of a daunting task in Canada today. So let's dig into how that oath is being tested and what it means for people everywhere whose eyes are open to eroding freedoms and the potential for slippage into tyranny. Daniel, welcome. It's great to have you on the show.
Thank you for having me, and thank you for doing this.
Thank you for everything you do. It seems like there are a frightening number of things that we could be talking about today. But let's start with that hiking ban in Nova Scotia. I noticed that you called it a social experiment. So let's talk a little bit about what do you mean by that? Is it that governments are testing how far they can push punitive measures to normalize them?
I looked at that ban and I was like, you talk about like the rational connection to the objective here of addressing forest fires, and whether any kind of precedent for this kind of thing. I guess Nova Scotia does have a precedent, quite a few precedents for banning people from the woods, but it's not a well recognized precedent. You know, it was surprising to see their eagerness with which the government imposed the mandate, and um, and the purpose. Like, if the real goal here is to stop forest fires, I mean, there are other ways, less intrusive ways. And
Indeed.
so, yeah, based on what I've seen just from COVID and how the government collects information about how people respond, I'm like, well, this would be, even if they're not doing it, I would do it as just a lawyer. I'm like, oh, let's see now, let's study this. How are people responding to this? You find your nodes of influence. Who are the major influencers now that have come forward? you know,
Mm.
so okay, now I know Jeff Evely's on the radar. He's going to be one of the in environmental lockdowns. He'll be the guy we have to target, or we have to keep an eye on him.
Right.
You see all the players, and so use this now as an opportunity. How like most people just don't care. I don't know. There's no protests in Nova Scotia about this. It's very strange to me. I guess there's not that many people interested in hiking in the woods. So, but yes, use this as an example, as a learning opportunity, like they did during COVID. Um, how do people handle it? And
Yeah.
it's interesting.
It is really interesting that there is so little protest, certainly publicly. There might be private conversations going on, but having lived in Nova Scotia, I can say that people do love hiking in the woods and foraging for mushrooms and just getting outdoors. And so this should feel like a huge impingement. And yet you really aren't seeing that kind of public outrage. It's very much a sort of, yeah, this is what we need to do. And so you're right. As a social experiment, I think there's a lot of information to be gathered. You mentioned Jeff Evely, and I think we should talk a little bit about him. He is a person who's standing up against a $28,000 fine that he was given. He did that, I think, on purpose in order to be able to press the issue because without it, he wouldn't have standing. Is that correct?
That's what the lack of standing in his prior case to me was like shocking, because here in that case there was a law that did intimidate a lot of people, that did prevent them from going to the woods. I would have thought anyone who decided not to go into the woods because they were scared of a fine that would have impacted them would have standing. This whole issue of standing is just, to me, is mind blowing. Um, so the fact that he had to go out and get the ticket, and by the way, I feel like I look a bit like Jeff Evely. I feel like our beard hue is very similar. Hats, anyhow. Point is, yeah, I think his strategy is a noble one. If his simple goal is to just get standing, I think that's exactly what you have to do. You have to videotape the encounter. You have to, show that you're not doing it in a dangerous manner. You're just doing it to enjoy the woods. And I really even liked how he recorded the interaction with the officer, the whatever officer they go, environmental officer. What do they call them? Um, he didn't film the guy. He just
Mhm.
camera down. He was very respectful. Like that. That's how it's done, and that's like that's the you see the soldier mindset in him. And I thought it was that was a real class act how he went about doing it.
How significant do you think this case is or could be from your legal perspective?
That's a good question. I think it'll be sometimes these things are so fact specific that it may not be and I wouldn't promote even if there was a ruling against him in the lower court. I wouldn't really use it as a precedent. Um, I firmly believe that there are some restrictions are warranted. Some harsh measures are warranted for people who start fires or who smoke where they're not where they shouldn't. But to just a system wide ban, indiscriminate fine like that, like that's not a ticket. That is someone's life savings. That is putting someone into the poverty line. That is making them go to the food banks. That's taking their house. That is a significant amount of money. It is not proportional. I've long advocated, by the way, that financial penalties can be, I believe, I don't say cruel and unusual punishment, but I think they can cross the border into human rights issues, even though technically this country doesn't really recognize financial penalties as a breach of any human right. But I've seen cases where it upends people's lives so much that it does cross, in my view, even though it's just a fine, it does cross, into real basic human rights. Um,
That's that's
right?
incredible. Um, and you, I think, have done some sort of back of the envelope calculations that a 1 week hike could theoretically lead to millions of dollars in fines and
That's right.
potentially years in jail. So this isn't a small thing.
Well, that's what's so silly. Like, you a lot of laws can be read foolishly, but they could also be enforced foolishly. So the fact that they're going for 7 years for Tamara Leach and Chris Barber, I think that's absurd. As do many colleagues, even those who were anti-convoy. So it's like it's the whim of the crown. It's like we really have to send a message. 7 days in the woods, knowing each day that that this person was getting a ticket. We cannot. You send the crown prosecutor for on the Tamale, like what's the name? Send him out there to Nova Scotia and have him do per diem fines and per diem, incarceration for each violation. And I'm sure he can put together a pretty good brief, making it sound normal.
Right.
But
It,
it's not normal. That is not normal. Even in Australia, where they have similar, very serious risks.
mhm.
Maybe their woods aren't as flat. I don't know what the deal is in Australia because they also have deserts. So, but they have major fires. They don't ban people into the woods, So
It's sort of mind-boggling. I mean, as you said, so some restrictions during particularly dry seasons are warranted, and there already was a burn ban in
yeah.
place, and so violating the burn ban carries a fine, and a pretty hefty fine. I think it was the $25,000 fine. That makes sense. However, they weren't actually issuing any tickets for people breaking the burn ban, but they are issuing tickets for people just walking into the woods, not lighting fires or causing any
Is that
problems.
true?
So
I didn't know that. Where was that? That was documented or that was
maybe it
reported?
wasn't documented, but it certainly it didn't seem like it was making it into the news that all sorts of people were getting ticketed for violating a burn ban by actually starting a campfire, say. That
Right.
wasn't happening. And then they expanded that into don't go into the woods at all, not don't start a fire during a burn ban. Burn bans are normal. People understand them. And for the most part, I think people are quite compliant with that. So it just seems mind boggling that they
No,
had to
look,
take it to this next level.
even our freedom-loving friends in the States have burn bans. I was surprised to see, right? And I think it even applies on private property.
Hmm.
There was one guy on his channel, saying that he couldn't mulch his, or he had to mulch his, the wood that he would normally burn because of the burn ban. I'm like, oh, cool, wow. So even, um, and I wonder if fires are harder to ticket because you have to get on private property. Maybe that's one of the limitations. I don't know how the warrants work. Like, can an officer just barge onto a property like we saw smoke there? Barge into property without a warrant, go into someone's home. Where's the fire? Well, I guess in a home is okay, but you know what I mean. Go into their property, and where there's smoke, there's fire. We know there's a fire. Show us the fire. I can see why it's more awkward to ticket for fires on private property.
Hmm.
So maybe that's why. But even at that, then yeah, if it's someone on crown land, an individual, easy to spot. We know where the ropes are. You know where that fine line is. You step over that, we're going to ticket you. That's our, it's it just really it's a manifestation of the COVID stuff that that brings it into just a different realm now, and
Yeah.
people anticipated this.
Before COVID, the idea of giving someone prison time just for merely being present on public land was just pretty much unheard of. And now we're at this stage with Jeff Evely and his case. I mean, what can you characterize what that change is all about?
Yeah, this concept of I actually I posted about this, and I was trying to find in the criminal code cases of where mere presence is itself the criminal offense. And so obviously there's court orders, where people can't, for intimate partner violence, there's mere presence in a certain radius, is illegal, is by court order illegal. Um, then there's other cases, bail conditions. You have to, mere presence in certain areas will be deemed to, put you back in jail. But the statute, I think voyeurism or being on someone's private property at night, or, very few cases where just mere presence is basically can land you in jail. Even a, trespass, that's private property. For crown land, like, you have to, there's conditions. You have to, like, to access government property, you have to go through searches sometimes, or there's times where you can, you can't be there. But it's very unusual to have government property, mere presence on government property, again, unless it's a, air force, an air base or a military base.
Hmm.
Very few situations where mere presence is a criminal offense or can be, land someone in jail. And so this concept of mere presence, mere existence being, something that can be incarcerated, it's pretty philosophically eerie, because I know it's one of our topics later, but okay, well, mere presence isn't, mere existence is an environmental and health cost concern. So let's move into medical assistance and dying to solve that problem. Like, I hate to be, expand the thing too much, but that's kind of the extremist version of criminalizing physical presence.
For sure. For sure. And along the way between walking in the woods and medical assistance and dying, there are a number of different moments where we can be locked out of activities that we once took for granted, or where more and more freedoms can just be taken away in the name of public safety or public health or the greater good, or all of these terms that they like to use. So it's not nothing to think about these things. And yet, as we've already said, it seems like there's a very high tolerance for these kinds of things. And that may just be part of the Canadian nature. It may be an impact of the Freedom Convoy and people not wanting to kind of repeat that. I don't know, but what are your thoughts on why we're seeing this kind of almost fear of rocking the boat?
It is a weird evolution of public thinking. I'm not sure why. I see now the nodes of influence on, I guess you call it the left or the far left side. Um, but yeah, some people are like, well, obviously we're just doing this for public, this entity called public, the public. Um, they've created this person that has that's just is a monster. This entity called public health or public benefit, um, and in trying to advocate for this entity, this beast, it's we're willing to trample on so many. They're prepared to trample on so many human rights.
Yeah.
And again, I also posted on this at one point, but like, just because something is a benefit, just because the public benefits from something doesn't mean it's right. That doesn't mean we should be doing it. That's the whole purpose of the charter. Like, there are so many policies that are beneficial to many people, many groups, but they're not correct. And that's the whole, like, so that's why we have fundamental freedoms. And that's why it's in the charter. These rights come from that recognize the supremacy of God, this concept of, right? There's a divine aspect to all this. So I don't know why there's this cultural shift now. I know everyone likes to call it Marxist, the communist takeover. I don't know if that helps the discussion because it just kind of makes things a bit more complicated. But I'm definitely seeing, even now, you're talking about criminalizing mere presence, okay? Take now the recent case in where was it? The Kawarthas, where mere presence in someone's home with a weapon at 3 a.m. That, like, in my mind, that's, someone's who prepared to commit culpable homicide in that case. Like, I think that's the assumption. But now it seems like you've got these leaders that are like, well, don't use too much force against that person, or the force has to be reasonable. I'm not sure what force is reasonable in that situation, except to treat that person as someone prepared to commit culpable homicide in that moment.
Early Monday around 3:20 in the morning, officers say a 44-year-old homeowner in his Lindsay apartment was awoken by an intruder, a 41-year-old man. There was an altercation. The intruder was rushed to hospital with serious, life-threatening injuries, then airlifted to Toronto for care. Police charged the homeowner with aggravated assault and assault with a weapon. Under Canadian law, individuals have the right to defend themselves and their property. The Criminal Code of Canada, specifically sections 34 and 35, allow a person to use reasonable force to protect themselves and their property if they believe they are facing a threat. However, it is important to understand that these rights are not unlimited in Canada. The law requires that any defensive action be proportionate to the threat. This means that while homeowners do have the right to protect themselves and their property, the use of force must be reasonable given the circumstances.
Now, I know, so the U.S. has the castle doctrine, which means you can just, anybody who's on your property can be killed. If they have no lawful right to be there. I think that's a bit extreme. I've heard of cases in Canada where there have been accidents where people have, been drunk and come onto the wrong property. I don't think they should be killed for that. Or they're just having psychotic mental health issue. They break into a home, no weapon, during the day or even late at night. I don't think those people should be assumed to be intent on committing culpable homicide. But someone who comes in the middle of the night with a weapon, the assumption at common law and under the criminal code should be that it's assumed that they will commit culpable homicide. And so that being the case, barring any, I surrender or putting down the weapon, barring anything like unusual, the assumption should be lethal force should be warranted in that situation. It shouldn't even really be a question.
Right.
Otherwise you're promoting, and that'll send the signal to the community, don't break and enter. It's a capital crime. With a weapon. And even a strong person without a weapon can be considered, can do a lot of damage. So, but the point is, I don't even know, everything's debatable, I guess, but like that should be pretty simple. We should all agree, like Andrew Coyne and Rachel Gilmore should not dispute that if someone has broken in with a weapon when it's dark, even know when it's dark, what are they going to do? They're not there to negotiate. They're not there to have a little chit chat about what I can take, what I can't. It's if they experience resistance, they will, likely use lethal force against you as the homeowner. So,
Right.
What
and as the homeowner, you should have a right to defend yourself.
Well, yeah. What are you supposed to do? Find a window? Like, one sec, I just got to go find a window to flee from my house. Like, I'm going to try to flee now. Like,
so you can have what I have in my house. It's yours, but just give me a chance to get away. What's really interesting about this, though, I think, is the public reaction to it. That this case has become the
Right.
point of a public conversation about what is right and what is wrong. And I think what you're hinting at is it shouldn't even be a question. Everybody should sort of feel as though if someone comes into my house with a weapon in the middle of the night, I should be able to do something about it.
Right, and I'm glad Pierre Poilievre and Doug Ford, they've all come out against it, and that's important. And I know one commenter was saying how they shouldn't be giving legal advice. I mean, that's not legal advice. That's policy advice. That's prosecutorial, discretion, or trying to have a discussion about what proper prosecutorial discretion in this case. And I suspect, if we're just to be clear, I suspect the Crown will drop it. I think they are going to look at it.
Mm-hmm.
They're going to say, "Nice try. We appreciate you were trying to, local police. We appreciate your concern here. We're dropping this. This is ridiculous." And it'll fall under the what is reasonable response in that case.
Mm-hmm.
Again, unless there are some facts here that that really make this like, what are you talking about? The guy put down his weapon. He was like, it was just a water gun. It was a practical joke. It was
Right.
a friend of the family that didn't, unless there's something like that, then if you didn't know the guy, and anyhow, yeah. So I'm glad it is. We are having a discussion about it now, and hopefully, if there's not amendments to the criminal code, which would probably be tricky with this government, then at least the public will raise awareness that this is not a case that should have ever gone this far. But again, the fact that people like Andrew Coyne and Rachel Gilmore, those are just two that come to mind, but I'm sure there are others. The fact that they're interested in entering this debate with views that are, I think, are kind of silly, it means that they may have a fault. Like there may be, millions of Canadians who still think that negotiate with someone in your house at that hour. It's like the hotlines are closed. There's no there's no negotiations with a home intruder with a weapon.
It's a really interesting one to kind of pause on because it sits really oddly next to the idea that, for example, in Nova Scotia, with all of these hiking bans, the government set up a snitch line to ask people to report their neighbors if they see them going into the woods. So we have this moment where, people are being asked to surveil each other and report each other for bad behavior. But then when someone breaks into someone's home, there's like forgiveness for that person. And, the homeowner maybe shouldn't have gone as far as he went. It seems like a real dichotomy between perspectives. And I think there's something to explore there about how we feel about each other or how we trust each other or how much trust we're putting in the government, perhaps.
Yeah, the snitch line is an interesting little hack from Nova Scotia. They should have had, during COVID, it would have been nice to have a snitch line, about employers that were implementing vaccine mandates and were violating medical and religious exemptions. Why didn't they have a snitch line for those cases? We know that there are tons of cases that came out where employers didn't follow proper protocol. They didn't properly evaluate medical and religious exemptions. A few arbitration and court cases found that there was wrongdoing there. Why wasn't there a snitch line for those wrongs? That's because you call the snitch line, and the snitch line, the first question the snitch line would ask you in that case was, "Are you vaccinated or not? Otherwise, I can't talk to you." That kind of paradox. So a snitch line for the fire bans, I mean, it's pick and choose your snitch line. Like there are so many other wrongdoings in this country. Why are we having a snitch line for just that?
Right.
And look, I think snitching when you can negotiate something face to face with someone and have the debate, like civilized people. I'm always leery of snitch lines. If you have a beef with someone, it's uncomfortable, have it with them face to face. And if you really have to escalate it, appoint a third party and have them solve it. I'm finding the third party is tricky, but that's why you have, arbitration groups that are mediators. But yes, the point is a snitch line to have an officer come out and issue a fine or arrest. Like, come on, is it that serious? Maybe if the guy's setting fire to friggin' areas, okay, let's call him. You don't need a snitch line, just get the police to come on scene quick. But
then you just call 911. If someone is doing something egregiously illegal, that's
right.
what we have 911 for. So this is a little bit nuanced, and it feels a little bit like a slippery slope. Today it's someone's going into the woods, but tomorrow it's just encouraging people to be monitoring their neighbors for bad behavior rather than actually building trust amongst
Right.
us so that we have a unified um, public actually watching the government. Instead, we're just watching each other and submitting to the government.
Yeah, look, and I guess if people really want to snitch, they'll find a way, right? They don't, it doesn't need, does it need to be promoted? Um, you know, if a store is selling expired milk, do you need a snitch line for that? What are you gonna do? Just let let the owner know and let other, post on Facebook.
Mhm.
But do you need a snitch line for expired milk? Oh, it's not the same. This isn't a safety. Okay, fine. This isn't a safe. So then, well, there's lots of things that are, have public health concerns that you could promote snitch lines for. So yeah, this targeted use of the snitch line, is it creating now splits in communities? Is it causing people to distrust one another? Is it eroding, the trust, like you say, the trust of a community? Yeah, and that's not good. Like there are, um, it intentionally or not, it does weaken the community, weaken community strength, and it makes people rely on government excessively, and it helps the government really overpower the will of the people. And I say the government, it's a few folks who benefit from this, not not the vast majority.
We mentioned in the introduction the oath that you took when you became a lawyer, and you've also mentioned the charter. And these seem like very important foundational documents, not only for you and your profession as a lawyer, but for all of us as a public to be aware of. And it seems like there is very little awareness of those. And now more than ever, especially having been through the COVID era, it feels like these are things that should be talked about more. They should be published more. We should be really digging down on what our rights are. Talk a little bit about your view and how that's changed um, during COVID.
Um, I mean, I think health and safety became so important that the oath, I don't think anybody consulted their oath. In fact, I don't even remember the oath. It's been 20 years. I had to actually Google it while I'm on you know, while I'm on this live stream. Um, but when you're in the middle of combat, you're kind of in autopilot. You're fighting the battle. In the case of COVID, it was the virus, and for soldiers, if you're in a war, you're just fighting. And so maybe the soldier in the back of their mind is always thinking about doing this for country, love of country, and I guess the same could be said for professionals who are just trying to keep everyone safe. That became the oath, is to keep everyone safe,
Mhm.
and to do our part. But it's more nuanced than that. Even though it was a declared emergency, um, an oath is an oath, and so what do? You forgo your oath. So someone who's unvaccinated, how do we treat that person? Are they really a threat, such that they are taken out of uh, the subjects that let's say lawyers are supposed to protect? I don't think so. Um, even known self-confessed criminals like murderers, they still get the benefit of the oath. So I think the oath was forgotten in many cases, um, and exactly, or maybe interpreted to the point of absurdity.
Right.
But it really was to find a way to balance better, and I don't think that was done.
No, it seems like safety is a very hard one to pin down, but the part of the oath that you swore is to champion the rule of law and to safeguard freedoms, and those two things shouldn't be anathema to keeping everybody safe. They should all three kind of go together, but somehow safety, which can be ill-defined, became more important than freedom or the rule of law. or that's how it felt anyway. So
Yeah, there's that, the rule of law, and how do you have law when we're in uncharted territories and we have to use emergency powers like that? The whole essence of emergency powers and the Emergencies Act is basically, we're suspending all legal privileges, and redoing the law in a way to prioritize public safety in this emergency. So I think, yeah, I guess the argument is that the oath gets, relegated, and the emergency gets prioritized. But like I say, it didn't have to be this way. I think even, you talk about something like access to justice, and what that means during COVID, post-COVID. Um, Access to justice means, you know, uh, if there's a dispute about the lawfulness, or the things related to COVID mandatory vaccination, or forcing disclosure of one's vaccination status. Access to justice means you may want a jury who has divergent views on this subject, and if juries are all required to get vaccinated, or if judges are all disclose their vaccination status, then you have a real manifest access to justice issue. Um, or perception of justice access, meaning, and sometimes you just, like, unvaccinated people couldn't even access the same services. So all these, I'm not saying that restrictions weren't warranted or justified in some situations, but there's been no proper review, self-reflection at any institutional level, and that's regrettable. I think the U.S. is starting to do it now with the CDC. They've changed the director of the ship there, so you're going to see more self-reflection there. Canada's got to do it. I'm trying to do it with the Law Society of Ontario now, but it's hard to get my foot in the door there.
what are you trying to do?
I'm trying to form a committee to review whether the vaccine mandate, that required the public to be vaccinated to access the Great Library up until August of 2022. I'm trying to, and how procedurally that was implemented. I'm trying to get a motion there to appoint yours truly to review the governance, and address the justification, how the former CEO justified that kind of restriction, because I believe there were procedural safeguards and transparency issues that weren't followed. Meaning, well, who gave the CEO to make that kind of power to make those kind of decisions? What was relied on up until August to exclude the public, from the Great Library and lawyers. Now the governance issues have come up because the CEO last year was awarded a significant financial pay increase, which was too distasteful for members, and so the process was evaluated, and she ended up resigning. And now, but in promotion of my neutrality, I don't think that was her fault in terms of, people want more money, they're allowed to ask for it. Mm-hmm. I think the process and the transparency and the lack thereof, that was the issue. So that's why I'm trying to get now a committee formed independently to review how the Law Society decided on the vaccine stuff, because Law Society directly and indirectly influences a lot of our justice system. And so it's important to understand if there was an error there, to have it reviewed, right, and addressed to prevent it from happening again.
And as you talk about this with the public or with your colleagues, what kind of reactions or pushback do you get? Do you get the sense that at this point there's a sort of vaccine fatigue, that people just don't even want to talk about this issue anymore? Because it's very relevant. It impacted a lot of people's lives, and it's not going away. There's potentially more to come that's in a similar vein. So, but what kinds of reactions do you get from people?
I haven't received much pushback, substantive pushback. I think there's just procedural pushback. In terms of my motion, I was 7 days past the deadline to bring the motion, so it can't be heard. But even at that, it's not binding. And if I don't think any of the benchers would really oppose, I can't say that. I don't know. At least the people that I've reached out to, they're just kind of either they're nonchalant, they're just like, yeah, let's move on, or they're just like, okay, let's like they're still passionate. So I've got my 10 plus signatures
Okay.
required. So there is those lawyers that in the know that did have clients that dealt with it. There is support, but yeah, I think just people have other things on the agenda.
Mhm.
But again, now that the this CEO pay is coming to the fore. I mean, to me, it doesn't come as a surprise for me, having seen the governance issue with the COVID stuff. I'm like, of course you're going to have this. There's the oversight and the public participation and the transparency is lacking. Of course, you're going to have a situation where something, once it get revealed, might be more surprising than you might expect. So, um, but yeah, like I say, overall, I think it's either yes, there's fatigue, but support, but no pushback.
Okay. Well, that's good to hear. I know that in addition to your work in law, you've started to lean a little bit more on public advocacy. Do you see that as potentially a more powerful way to evoke change than through the courts?
That's a good question. Um, I think the courts ultimately, um, and the decisions of lawyers that are getting the cases that are able to go all the way to trial, I think those are powerful and helpful. And so they're just not getting promoted. So that's kind of what I'm doing, um, promoting those cases. Most of cases settle, and they sign NDAs, so you're not going to hear about them.
Hmm.
Um, I can't talk about my clients can't talk about the cases we've settled, um, but there are a few that have gone to trial that have been successful. And I think yes, it is important to raise awareness. So to the short answer is I think both are required. I think you got to go through the courts. There are good decisions are, not always, but there have been favorable decisions. They're not getting promoted. Um, and maybe hopefully they'll find their way into, the minds of executives when, not when, but like if people solicit that kind of opinion again, those kind of legal opinions, like don't do it. Find another way.
Hmm. What kind of strategies do you use on the advocacy front? And is it mostly targeted to the public?
For advocacy, yeah, like my main channel is just X, just spewing an idea here and there. I like to have for my opinions based on um, some documents. I usually provide supporting links. Um, so I think just bringing a lot of these to the attention of the public is helpful, and I think it does worm its way into folks' brains. Um, my credibility has increased, even on Twitter. So like I have been reposted by certain government accounts. I have been able to now, change publications of certain government, certain health publications. One was a CDC-backed website. I was able to get them to change small things,
Yeah.
but they add up, right? So CDC, Alberta Health Services, they all change small things that are important, just in terms of showing that, yeah, we're just members of the public, but we can, with a bit of reason, common sense, and accuracy, we can influence and make changes.
One of the issues that you do talk about on your X channel and elsewhere is medical assistance in dying, MAID, and we mentioned that earlier, and I think now maybe is a good time to dig in a little bit more on that. So the law has expanded in Canada recently. We recently read a statistic that 1 in 20 deaths in Canada are now caused by MAID. So that's not an insignificant number, especially in a fairly short period of time in which this legislation change has happened. So, talk a little bit about your thoughts on that expansion and um, what it means really for the public in Canada.
Well, I grew up with my mom was a palliative care nurse. So I grew up in an environment where supporting people, at the end stages, was just part of was part of this social contract. And in cases, but there was tension in cases of extreme pain. someone who's like basically being tortured on their way out, what to do in those situations. And so that's kind of where, on a case by case basis, there was some compassion, and being too strict did create some problems when basically end of life was torture and there was no way to alleviate with pain medication or anything. But I grew up, yes, in an environment where that was the norm. And so the norm being to take care and to palliate. But there was a shift that occurred after that Supreme Court decision where, the constitutional right to die, and not just by self-inflicted, like not just a person taking their own life, which, shouldn't be promoted in its own right, but this was assistance in like having third parties involved in this, and whole organizations and institutions now part of it. A decision for one person to on themselves is one thing, but when it requires the enlistment of public funds, public resources, and paid healthcare workers, it requires a different framework, I think, because it is technically it's culpable homicide unless you have unless there's a statute to exclude it. So once it expanded because of our courts in I think it was the Cartier decision, where it was a constitutional right to enlist the support of a healthcare worker, the government seized on that opportunity again, all be for the public benefit, the benefit of the purse, and not just for. I don't think that many patients were advocating for it, but I think it was the government looked at the benefits, the cost benefit of end of life care, and they realized that it would be the financial reason was itself provided some justification, it seemed, in their mind. So you had to expand into not just pain, not just physical pains included, but any case preemptively, like you can get ahead of the curve. And now they're expanding into psychological conditions. It's surreal in a way. If you don't have that bright red line, then that line gets shifted, and by whom and for what reason? That's kind of where it gets really nasty.
Yeah. Let's talk about some of those issues. So, in some ways, Europe has been ahead of North America on this issue. Canada, with this expansion, is in a way catching up, but in some ways taking over, almost taking first place on the ways in which this law is being expanded, making Canada a little bit of an international outlier, I think is how you framed it. Talk a little bit about what makes Canada's situation different.
That's a good question. I can't really explain it. Like even when I looked when the numbers first came out, and because Canada and California have comparable populations, but the rate of it, and I think they were expanding MAID at least for certain eligible groups. They had expanded it at one point at the same rate, but California wasn't taking up the offer. So I was like, man, what's in California that people just want to live? So California Sunshine, California Dreamin', I guess all those songs about California. I think something about maybe just the climate, like if people are in rainy climates, maybe, or if that's part of it. I think connecting it to our earlier discussion, I think just moving in lockstep and not really questioning things. I think that's also part of it. I think a lot of nonprofits and charities are getting federal funding to promote MAID. If you look behind the curtain for a lot of these organizations, it's they're getting that at the federal level. They're getting the funding, and that helps promote it. And then you just don't get the pushback. And if there are costs involved in treating underlying conditions, again because it's public money, you don't want to spend the money when you can save the money. So I think that has to do with it. Like, so in other words, I thought maybe the private care, the fact that medical, there's more private care in the States, where there's like in a way a duty on private health insurers to kind of make a bit more money by keeping people alive longer. So maybe that's why it's different too. But I can't really explain it.
Yeah. There's an interesting perversion that you just mentioned, because now there's a profit motive being presented in Canada to not provide healthcare, but to provide MAID. So these nonprofits that now exist to provide this service that are getting government funding, if people aren't taking them up on their offer, they're going to lose their funding or it's going to be reduced. So there's an almost perverse incentive, and it may not be conscious, but it's there. There's organizations that provide this service that have marketing budgets and advertising budgets to let people know that they can do this. It really kind of turns the whole idea on its head. Especially, I mean, one of the big differences between Canada and California is that Canada has government healthcare, which is, the government's mandated to provide healthcare, not to just offer everybody the opportunity to die when they want to. It seems very confusing that way.
It is. It is. And I'm trying, again, I try to figure out why the U.S. isn't into it. Maybe because there's more states that are more religiously entrenched, you know. But let's say even in California, I guess they are expanding MAID, so maybe that's where they're going with it, because you got to figure, so someone's got to pay for end of life care. The question is who. People that can't afford it in California now, if they need end of life care, okay, so they go into a hospital, the hospital starts running up the bill, and they try to collect it off the person in the hospital, the estate. Maybe they can't, but the state's not going to pay, as of now, the state's not going to pay for that person to be, that person's MAID, I don't think, because it's not really, they don't want to spend more money and they're not paying it, they're not taking the financial hit in the first place. But in Canada, yeah, it's different, to the point where in Canada now they've addressed this. They're trying to in the other way, which is, if someone goes into a hospital and they require a lot of care, and it's not efficient, they should be to, let's say, a long-term care facility. I know now what they're doing is they're putting them in places where it's cheaper to care for them, even without their consent. And if they don't comply, the costs are massive. They'll take everything from the estate before they die. The government will just take it all because we're tired of paying for it. So that's the other way to do it. Less MAID, more just taking everyone's property at the end of life.
I mean, it's really nauseating to think that this expansion really just comes down to economics, and yet you can't help but question that. But it's also one of these issues that's tied up very much in compassion and care, and all the words that can be used to make you, if you oppose this idea, to make you seem like a person who doesn't care about feelings or doesn't care about other people. Do you think that really it does come down to an economic argument, or is there more going on the ideological front?
I mean, I think I wouldn't say it's all financial. I think that's just a behind the scenes benefit. But I think there is this sense of compassion. Like if in the case of someone who's really suffering, then I think it is guided by compassion, and so in that sense, I think it's well intentioned for the most part. But I appreciate that. Look, religiously, in many religious traditions, it's just you cannot lay hands on someone's, even if they're in pain, you cannot lay hands on someone to kill them. It's murder. There's no negotiation. You can do it and plea for forgiveness, but in most traditional faiths, it's considered culpable homicide. To lay hands on someone to end their life, even if it's well intentioned. So how do you work around that in a secular society or in a society where that has to accommodate these divergent views? So I would have thought that the reasonable accommodation is to give flexibility to someone to do anything they want to themselves. And I think many states have gone that way. They've basically allowed doctors to provide the tools, but they won't actually allow the doctors to lay hands on a patient. And that's, an interesting way to resolve the religious and secular conflict, I think. But I wouldn't say it's all, sinister.
Right.
But but there still is a component. And there's a lot of people, there's all this talk with the carbon tax and punishing carbon use, and end of life is very carbon intensive. So um, there's definitely a dark side to it
For
as
sure.
well.
It just, I think it speaks so clearly to the moment that we're living through, where many of us have so little trust left in the government that the last thing we want is the government helping us to die. Um, Although, reasonably speaking, as you say, your mother's experience in palliative care, and we've had personal experience with that. It's a wonderful thing to help somebody reach that last moment of their life with dignity and as minimal amount of pain and suffering as possible. So, you know, expanding the opportunity for people to die in a way that's not traumatic for them is great. But then we've now taken it in Canada to far greater lengths than just those people who are terminal and incurable. And that's where it really starts to feel like overreach. And then you start to say, why? Why is this happening? And is there an economic component to it?
Right. And to there, I think it boils down to promotion. Like, you don't need to promote it. Like, there were coming up on my Google searches when I was just Googling the topic. It was a sponsored post by this charity. You don't need to sponsor. You don't need to, pay money to bring it to people's aware. Like, if they need to raise awareness, someone in a healthcare setting can advise on it, those who want to. By the way, that's the other issue, is that it's no longer just an option. There's an obligation now for health regulated professionals to inform people about all their entire care
Wow.
options. And so a doctor can get into trouble if they don't properly explain that there is a medical assistance in dying option. And so that's where it starts interfering with other people's rights. Well, okay, I don't want to talk about that. I don't want to raise that as a doctor. I'm like, wait a second, this is misconduct. You're not providing full spectrum of care to this person. You're supporting torture. Um, there's now, the CPSO has issued guidelines and obligations on doctors. And if, like, okay, we'll respect your right. If you don't want to get involved in, if it's your understanding of the Hippocratic Oath, you don't have to, but you have to provide at least a referral. You have to refer it to somebody who will. So, like, I don't want to give a referral either. Okay, well, now you're offside. You're not prepared to provide a referral. We're taking away your license. That's where it's gone. That is basically where it has gone. And I don't know if it's gone to the Supreme Court, whether someone can protest an effective referral based on conscience or belief. But I would hope the Supreme Court would allow the person to say, I don't want to be involved. Go there's other people in the hallway you can talk to. Don't get me involved in it. That's what I would think is a responsible outcome for that situation, to accommodate everybody's rights here.
What's really interesting in what you just brought up is that there's developing now in Canada and the United States and other places this level below the law of these governing bodies, these licensing bodies. And we spoke to a fellow Canadian lawyer, Lisa Myron, about this issue, where, you may not be breaking an actual law of the land, but if you don't do what we say, we can take away your license to practice. We can kill your livelihood, so to speak. And that suddenly starts to moderate how people behave, how professionals behave, in ways that go well beyond what the law would allow.
Right. And where I saw that was with the CPSO. There was a lot going on behind the scenes there. Like, I think 98% of COVID issues, social issues, could have been solved had doctors been allowed to write medical exemptions at their sole discretion, unfettered discretion. And the only reason they weren't able to write medical exemptions was because of fear of the CPSO, not fear of the law, fear of the CPSO, and just being harassed. And so I've tried to raise awareness about this to the point where they blocked me from accessing public meetings, open to the public. These are open to the public meetings, but they have
Except you.
blocked me. Except me. Well, first in December of 2022, it was anyone who refused to show their proof of vaccination. So that was everybody. Then everybody again in 2023 on the basis of safety concerns, and you could log in virtually, but nobody sees you or you can't speak or mingle. So it's just, and then yes, most recently at the last meeting, because they were concerned that I was going to serve a document individually on each member of the board. And so they were concerned that I would drop a piece of paper on a table. And so I was not allowed in unless I surrendered the papers. And I said, I don't have to surrender papers to go to a meeting. I can give you an undertaking that if you think that that's going to disturb people, I won't do it, but I'm not giving you my papers. And so we had a back and forth. They refused to let me in unless I surrendered my papers. I said, what the heck is going on? I finally spoke to the lawyer for the CPSO, and they eventually let me in with my papers. I didn't distribute them, but I was allowed to keep my papers. So my point is that people have to understand that the CPSOs, the college's role in the threats that doctors face, and how they really were not able, so many of them were not able to do their job the way they wanted to because of fear of their regulator.
And do you think that the same thing is happening in the legal profession as well?
Thankfully, I think the nature of law is a bit different. Like, we embrace dispute. We love, certain, arguing things. But I guess they're, to a point, I guess, for just by way of example, when, in terms of challenging the Law Society, there was a case where one of the benchers, and that's like the board members, one of the benchers was trying to access information about certain policies and agendas that the Law Society was implementing. And he asked for some, this was with respect to, I think, the DEI stuff. I forget exactly the details, but he wanted records of like what information the Law Society was relying on. And they refused to give him material. Like, these are survey results, stuff that should have been available to a board member. So he had to sue the Law Society. And you have to find a lawyer to sue the Law Society. I'm like, well, that's easy. There's 50,000 lawyers in Ontario, but no lawyer wanted to sue the Law Society in Ontario. I'm like, well, okay, why? Like, they're just a regular legal entity like any else, right. And that's because the conflict there. Mm-hmm. So I think you had to get an Alberta law firm to sue the Law Society of Ontario. Yeah. There are a few lawyers out there that still are they swear by the law, not the institution, and so they wouldn't have an issue. They're harder to find in Ontario, and there are legit conflicts of interest that have to be monitored. But for the most part, I mean, there should be it shouldn't be that hard if for lawyers to speak out even against their own law society for certain things.
What is your final message to Canadians who still think that MAID is about compassion and choice and that hiking bans are just about safety? What would you say to people who are not kind of seeing things in the same frame as you?
That's a tough one. I guess just critical thinking, undervalued skill, undervalued, desire. It's a lot easier not to think critically. It saves time, and you can outsource your thinking. I'm guilty of it a bit sometimes myself with using artificial intelligence to give me quick answers to things. But at the end of the day, when it comes to ethical things or situations that require more evaluation and challenging, like, don't just outsource your critical thinking to others. It's like, engage in the battle and don't be shy. And that's my message.
Wonderful.
Critical thinking.
Well, this has been a fascinating conversation. I really appreciate your coming on. Before we let you go, just remind people how they can find you and follow along with your work.
Yes, thank you. My advocacy stuff, so my personal opinions are on various topics, are at Lion Advocacy, and my legal channel is Lion Law Professional Corporation, Lion Law PC. That's also on Twitter, but you can just go to lionlaw.ca. And I try to focus on dispute resolution, how to bring business partners back together or find amicable ways to wrap things up. So that's how you can find me.
That's fantastic. Well, again, thank you so much for everything that you're doing and for being a clear-eyed critical thinker.
Awesome. Thank you for having me.
Friends, that certainly was eye-opening. Let us know your thoughts in the comments below. A huge thanks go out to Daniel Freiheit for breaking down this globalist grip that we're seeing in the Great White North, and it is a wake-up call to all of us. Thank you for tuning in. If this hits home, hit that subscribe button, give us a like, and share this video with anyone who needs to hear this. If you want more, head to collapselife.com and check out our content and sign up for our newsletter. And if you like what we're doing, think about a subscription. It's only $8 a month, and those funds go to help us dig beneath the surface and bring you great guests and compelling writing. Or you can swing over to our Buy Me a Coffee page and support us with 1 coffee, 5 coffees. It doesn't matter. Good journalism needs caffeine. We'll be back next week, and we look forward to seeing you then. Until then, keep your chin up. It's only collapse. See you soon.